Okay, in this class, I'm going to be discussing the copyright duration of copyright, or the copyright term, which currently depends on the nature of the work in question. So if the authors of a work are natural people, then broadly speaking, the copyright term is the duration of the life of the author, or the longest lived author, plus an additional 70 years after the death of the last author of the work in question. So if there's one author, it would be pegged to the life of the one author. If there's multiple authors of a joint work, then when the last author of the joint work dies, the copyright term lasts an additional 70 years. However, in the case of works made for hire, where the assumption is that the employer, who is the author for the purpose of the Copyright Act, is an entity rather than an individual, the copyright term lasts for a fixed term of 95 years, or 120 years if the work is not initially published. Because of course, entities don't have a fixed lifespan. You can't have a copyright term that's pegged to the life of the author if the author is the employer and typically an entity. Of course, it's possible that the employer could be a natural person as well. Nevertheless, works made for hire, irrespective of the nature of the employer, are going to have a fixed copyright term. Okay, so how about the history then of the copyright term? Well, the history of the copyright term is of the term gradually expanding. And for the overwhelming majority of the history of the United States, the copyright term in the United States has been a fixed term, initially derived from the Statute of Anne and gradually extended over time, right? So the initial copyright term was a maximum of 28 years, 14 years initial term, and potential 14-year renewal term. And in various revisions of the Copyright Act over the years, Congress extended that copyright term by making both the initial term and the renewal term longer. Now, the 1976 Act reflected a really major change in the way that the copyright term was computed, as well as many other aspects of the copyright law of the United States, in large part because the primary function of the Copyright Act of 1976, for better or for worse, was to align United States copyright law more closely with international copyright law as expressed in the Berne Convention. And among other things, the copyright term in the Berne Convention was pegged to the life of the author. So United States copyright law did the same thing, pegging the copyright term to the life of the author and adopting an additional 50-year term. Okay, now, Copyright Term Extension Act of 1998 recognized essentially that the sort of typical copyright term in most European countries had been extended from life of the author plus 50 years to life of the author plus 70 years, and essentially decided to do the same thing for works in the United States, adding an additional 20 years to the copyright term. Now, interestingly, unlike many of the previous revisions of the Copyright Act, the Copyright Term Extension Act was retrospective. In other words, it added an additional 20 years to the copyright term retroactively to works that had been created previously, right? So all works got a longer term as opposed to works getting a longer term prospectively. And in this chart, we can see the sort of gradual expansion of the copyright term over time, right? So as Congress has amended the Copyright Act, it's gradually made the copyright term longer. Now, this provides, I think, an helpful opportunity for us to think about the justification for copyright law in relation to the justification for the copyright term. In other words, if we reflect on the sort of triumvirate, as it were, of traditional justification, theoretical justifications offered for copyright protection: the economic theory, consequentialist theory, the Lockean theory founded or based in the natural right to property ownership, and the Hegelian or Kantian theories based in the right of the personality, the right of self-expression and self-realization. We can think about the copyright term perhaps in different kinds of ways. I mean, after all, under the economic theory, at least if we take the economic theory seriously, we ought to be looking at the incentives that copyright is providing to authors and asking, is extending the copyright term going to offer salient incentives to authors who might not otherwise create works? And in fact, we might even start asking, right, is the copyright term already salient to most authors, right? Why are we giving this much time in terms of copyright protection? Is it actually effective? Do we need to give it to all authors? Does it make sense to make the copyright term the same for all kinds of works, or maybe some kinds of works could have different copyright terms, right? Why are we doing it the way that we're doing it, right? Under the Lockean theory, it seems kind of hard to understand why the copyright term should end at all. After all, if people have a natural right in the works of authorship they create, then why should that end? Why shouldn't it be perpetual? And many artists and authors over the years have argued that copyright should indeed be perpetual, as we've noted earlier in the class. Finally, when it comes to the kind of Hegelian, Kantian personality and self-realization based theories, right? It gives us another opportunity to reflect sort of on, what the term should be and why the term should have a particular duration, right? I mean, how long do people need to realize their personality? And more to the point, what's the reason for maintaining copyright protection after the death of the author? Is it consistent with these theories to think that the legacy of the artist or the author will be maintained and managed by others after their passing, and that maintenance could also implicate some of those personality and self-realization rights that would otherwise be salient when a person is actually alive? Okay. Well, let's think about this in the context of Eldridge vAshcroft, in which the Supreme Court confronted squarely the question of the copyright term, the justification for the copyright term, and sort of the rationale by which both Congress settles on a copyright term and the Supreme Court does or doesn't take up the capacity, as it were, to review Congress's decision as to how long copyright should last. So Eldridge vAshcroft was focused on the Copyright Term Extension Act of 1998, otherwise known as the Sonny Bono Copyright Term Extension Act, otherwise known by many of its critics as the Mickey Mouse Protection Act, as it was widely viewed as a term extension imposed on the copyright term in order to ensure that valuable copyrighted assets like Mickey Mouse did not pass into the public domain, right? In other words, kind of re-upping copyright protection in Mickey Mouse and other properties for a number of years in order to ensure that their owners could continue to generate considerable profits from those copyrighted properties. And essentially the plaintiffs in the action were people who were in the business of using copyrighted works of authorship, or rather copyrighted works of authorship that had fallen into the public domain or for business purposes. And their argument was that by retroactively extending the copyright term, by giving additional copyright protection to works that had already been created, Congress was exceeding the scope of its authority under the Copyright Act. Specifically, the fact that the intellectual property clause authorizes Congress to create patents and copyrights, but only authorizes Congress to create patents and copyrights for limited times. Right? So the argument here was that it's exceeding the scope of the limited times limitation on copyright protection under the intellectual property clause, insofar as Congress is offering additional protection to works that already exist, because for a number of reasons, right? For one thing, Congress could theoretically continue to extend the term and never allow the works to go into the public domain. Moreover, if we think about copyright in kind of an incentive-based way, well, you can't provide an incentive for someone to create a work that they've already created. In other words, if there's a copyright quid pro quo, something for something, if the public gives copyright ownership to authors in order to encourage authors to produce those works of copyrighted, those copyrighted works of authorship that they wouldn't otherwise produce, well, there's no quo if the work has already been created. So here it looks like a kind of naked giveaway, right? Congress is just saying to authors, well, we gave you something, we gave you copyright protection in the past in order to encourage you to create this work of authorship, and we just wanted to come back and give you a little bit more because we like you so much and we so deeply appreciate you having created this work in the first place that we'd like to give you additional protection. And the plaintiffs say here that that's unconstitutional, right? That that exceeds Congress's authority. Congress can only grant copyright protection when it has some conceivable expectation that the public will receive something in return. And here, because the works have already been created, they already exist, there's no possibility for any even conceivable return, any conceivable benefit to the public of extending copyright protection. That's the term of copyright protection, because we already have the work, right? So all the public is doing here is giving an additional benefit and getting nothing in return. In addition, they point to First Amendment concerns relating to the extension of copyright protection, that essentially people have relied upon the expectation that works will fall into the public domain, and that retroactive extension has meaningful First Amendment implications with respect to their ability to use and engage in expressive activities in relation to works of authorship. I think the strongest argument is the retroactive extension one. And essentially what the majority opinion in Eldridge vAshcroft does is to say, look, this is congressional action reviewed under the rational basis test. That's already a bad sign for the plaintiffs here, of course, because the rational basis test is essentially best understood as telling the plaintiff you lose no matter what, because it's an extremely high burden for a plaintiff. In fact, the sort of canonical articulation of the rational basis test is, you know, like, if any possible conception could justify the congressional action, even if Congress didn't articulate it and the courts have to come up with it themselves, then that's sufficient to satisfy the rational basis test. And so unsurprisingly, the court says rational basis test means plaintiffs, Congress's actions are sufficiently justifiable that they could be treated as rational. It's not hard for Congress to make that showing, and Congress could have believed all manner of things that would have justified its decision to retroactively extend copyright protection. For example, Congress could reasonably have believed that retroactively extending copyright protection would encourage people to make works more available. In reality, it doesn't seem to be that that's actually the case. In fact, copyrighted works are less available in the aggregate than public domain works, presumably because copyright imposes transactions costs on making works available, but Congress could have believed it, therefore that's good enough. In addition, the majority observes that copyright owners might have felt that it was unfair that prospective copyright recipients would receive the additional 20 years and that they would not. It's not clear that the experience of unfairness is necessarily relevant to the rationality of the retroactive extension, but nonetheless, that kind of reciprocity, also reciprocity with respect to European copyright, the idea of harmonizing US copyright, that also played into the rationality angle again, seems sort of orthogonal to the plaintiff's argument, but the majority did not find that a compelling problem and essentially said, we're not going to second guess Congress's decision to retroactively extend copyright protection. Now, there's two long and very spirited dissents, one written by Justice Stevens, essentially saying that we shouldn't allow Congress to just make giveaways like this. Basically, Justice Stevens says we should take our responsibility to review congressional action more seriously, and under the circumstances, there's no compelling reason for Congress to do this. In fact, there's no meaningful justification for Congress's decision. Justice Breyer concurs with Justice Stevens's dissent and also offers a considerable amount of empirical information suggesting that it actually does not make any rational economic sense in a kind of incentives-based way to provide additional protection, because the time value of copyright, as it were, rapidly decreases over time, and the only meaningful effect of providing this additional extension is just to give a big giveaway to people who already knew that they had valuable assets they'd been exploiting for a long time, and the CTA just gave them some additional time to exploit the economic value of that limited monopoly granted to them by copyright protection. So I put it to you to reflect on like what we should think about Eldridge v. Ashcroft, right? I mean, what do we think kind of writ large about Congress's decision to offer that additional 20-year extension of copyright, especially to offer it retroactively? And more to the point, maybe, what do we think about the approach the majority took to analyzing the justification for making that decision? In other words, should the Supreme Court just defer to Congress's decision to make this additional grant of copyright protection, or should the Supreme Court, look at its decision with a little bit more of a jaundiced eye and apply a greater degree of scrutiny and ask about the wisdom of the decision and whether it's consistent with the actual theoretical and meaningful and philosophical authority granted to Congress under the Intellectual Property Clause. Indeed, I would note that there are other ways in which the Supreme Court has observed that the Intellectual Property Clause does limit Congress's authority. Like, for example, Congress can't grant copyright protection to ideas, even if it wants to, because that would exceed the scope of its authority and be unconstitutional. If that's unconstitutional, why shouldn't other kinds of grants of copyright protection be unconstitutional as well? In other words, should we analogize from that to retroactive extension and ask whether that's consistent with our expectations of Congress?